From Saturday, Ms. van Wyk has been sick. And I do believe in her first appearance on behalf of Mr. Matlala, at some point she intimated that she suffers from rheumatoid arthritis. That has put her in a position where she's so ill. I was engaging with her this morning. She can't use her hands or feet. She's with the doctor and they're consulting to see a way forward. But what she did guarantee me is that hopefully with the medication that she's receiving, by the afternoon she'll be in a proper position where she'll be able to continue with us working and appear tomorrow to argue. So my instructions right now, having considered the fact that we are constantly being hit with umthetho awuvumi, you cannot do this or that, and we have to try and navigate the systems where ordinarily a layperson not sitting in this commission would think, well, these individuals are incompetent, or maybe perhaps they're trying to not come before this commission in good faith. That is not the position. You have to be in it to truly understand what it takes for you to properly represent Mr. Matlala, because he is not an ordinary witness that you have access to at 12 a.m. rather in the morning, or at 3 a.m. in the morning. We don't have that liberty before us. And I do know with regards to the additional bundles that we receive later on, they make it even harder because he wants to read. He wants to know what's being said there so that he can give us proper instructions moving forward. He's not in a position where he feels comfortable that it would be smart and wise for him, given the status that he holds outside of the commission, to say to the commission, well, I did say let's go ahead, without considering the implications that it would have on him. Until tomorrow morning, at which point we had made an undertaking that we would have served you with our replying affidavit and our heads of argument. And so what the instructions are is that our application on an urgent basis would interdict the proceedings of the hearing or him giving testimony pending the reviewing of the ruling that you would have made, which is that we must proceed with arguing this matter, because he's of the view that it's unfair that he's been placed in this position where he has to proceed without Ms. van Wyk, who is his lead counsel, and without heads of arguments before you, which he believes then implies that we are not properly prepared and we're being strong-armed into proceeding.
Now, this time around, you've not said anything about the afternoon. It's what you said about the afternoon that I want to understand.
Yes, Chair, what I meant is that if we stand out now, it'll imply that we only have this afternoon and evening, I suppose, to ensure that we get the documents before the commission. So that's what the afternoon referred to, that if you do change your ruling into us standing down or postponing until tomorrow, it means that it's just this afternoon that would have to ensure that we have bring the documents or serve them on the commission and the evidence leaders. That's what the afternoon was.
Oh, you keep repeating that because you don't have your written submissions, you are not ready. Written submissions, yes, they do assist legal representatives, but in the main, written submissions are prepared for the assistance of the decision maker and not so much the arguer. Do you want to address us on that distinction? So those would more have been of use to us, but seeing that the written submissions are not there,
we get our kitty and we walk away. In the instance you rule that no, we are proceeding, our options would be to go off record as his counsel, and he would be without representation, it implies. Given the fact that...
Counsel only or counsel and attorneys?
Counsel and attorneys.
So, or you will no longer be representing him?
That's correct.
Yes, yes.
So that would be the hypothetical scenario that we'd find ourselves in if you decide that you're not willing to give us the additional time to come through prepared tomorrow. Again, I do want to stress the undertaking that we're making, which is that should you decide to rule to give us the additional time, whether Ms. van Wyk is here or not, we will be proceeding to argue. Whether you have received the papers or not from us, we will proceed to argue orally with or without the papers.
You say when?
Tomorrow morning.
Tomorrow.
Should you decide to rule in our favor that we should go home and come back tomorrow prepared. Thanks, Chairman.
Thank you, thank you. Go
ahead. Ms. Missy, when you say off the record, you mean you withdraw as his legal team?
That's correct.
Would that go for Ms. van Wyk? Heifer as well?
Those are the instructions that I received as well with regards
That
to, so
you
it
would
would be
also
the
withdraw.
entire team.
Okay.
Thank you, Commissioner.
Oh, and there was...
was another team yesterday.
Yeah. When she placed you on record, Ms. van den Heever, last time, she said there was another firm of attorneys as well. Are they present here, and do they also withdraw? Because it's not just the people that are sitting behind you as we understood her.
Yes, I actually just realized right now that Mr. Maluleke is and his firm still is part of this team, so they would also withdraw from there. Can it be the entire team, all attorneys and counsel?
And that's your instruction from Mr. Matlala?
Those are our instructions.
From Mr. Matlala?
That's correct, hypothetically speaking.
Okay.
Yes.
Mr. Maluleke is not with you. Has there been a discussion with him? Because it's important that we don't end up with a situation where, if this eventuality that you're contemplating happens, that we don't end up with a situation where he comes to the commission and said, I never put myself off record. The team that was here on Monday were not speaking for me, and I hadn't spoken to Mr. Matlala. So I think it's very important that we are clear about that.
I'm glad that you raised it, because that could potentially happen, hypothetically speaking. And with that being said, because these are instructions and engagements that we had with Mr. Matlala, and Mr. Maluleke is not here in person, I suppose then, in fairness to him, he has not commented on that element. These are just instructions that the entire team would be off record. But I suppose in that instance would have to engage with him and consider his stance should we find ourselves in that position. I suppose there won't be a need for us to stand on further until we've had a ruling. It just gives an idea of where we potentially would be. And if that is the case, we'll engage him and inform the Commission of his position.
Yes, I think, Ms. Missy, this eventuality that you're contemplating, I think it's very important that we all are clear what it is you're saying. You are using language of the record. My experience is counsel say, I'm withdrawing. I'm no longer on brief. I'm not counsel on brief in this matter, and I'm withdrawing because for their personal reasons or because that's the instruction from the client. So just so that there's no confusion, can we clearly understand you? You are saying in the event you do not get, I'm going to say your way, because that's what it is. If you don't get your way, or Mr. Matlala's way, you are saying to us your instruction from Mr. Matlala is that the entire legal team, and I'm happy to leave aside Mr. Maluleke for now, you're saying your instruction is that the entire legal team, counsel and attorneys, including Mrs. van den Heever, you withdraw as counsel.
That's correct, Commissioner.
Okay.
That's
Thank you.
correct.
Who is the senior attorney? This is something that that's so crucial that I think we should hear from the attorneys directly. Who is the senior of the attorneys? And
That would be Mr. Abaloi.
Please come to the microphone and please state your name for the record.
Thank you, Commissioner.
And your firm.
Yes, it's Mr. Baloi with initial N from Baloi Attorneys in Pretoria. Yes.
I asked if you also confirm that if our decision is that we proceed with Mr. Matlala's application, is your decision that you, as Mr. Matlala's attorneys of record, are withdrawing from representing him? If our decision is that we are proceeding, is that, do you confirm what counsel said?
Yes, I do confirm the submission made by the council.
You will be withdrawing, yeah. Perhaps, thank you very much, Mr. Baloi. I think we've reached the stage where we should. Ms. Hasim, I'm not sure that you would want to say something, but perhaps because this is not really your decision, if haven't we reached a stage where we should just indicate what we think?
Chair, there was
or what I think, because I think our regulations and rules really say that process-related decisions are mine, and indeed all rulings that have gone out go out, even if signed by the Commission Secretary, they go out under my name. But of course, for practical reasons, I'm always assisted by my co-commissioners, but ultimately it's my decision.
Chair, there's
yes.
nothing that I can usefully say in response to the last
Yes,
submissions that have
yes.
been made about withdrawing, etc. So it's in the Chair's hands.
Yes, thank you. I will address Mr. Matlala directly on this. Mr. Matlala, I just want to get an idea whether you two confirm that after your counsel or legal representatives were afforded an opportunity to consult with you, what was agreed upon is that if my direction is that we go ahead with your application, they will then withdraw as your legal representatives.
Thank you, Chair.
Can you please switch on both microphones? Yes, thank you.
Thank you, Chair. Chair, we had 3 scenarios, so I'm actually in the dark now because while I was having lunch, I didn't have enough time to conclude what we've been discussing, so we just came right straight here. So I do not know whether my legal counsel, what they are saying now is what comes from Mrs. van der Heever as instruction or not. So I'm actually in the dark. I don't know what to say.
So basically, you are not really party to what has been announced.
No, we've discussed the options, yes,
Okay.
but I haven't had the time to make up my own mind. So,
all right. Maybe the best is for me to announce the decision. Having considered everything that has been presented to the Commission, my decision is to go ahead to hear Mr. Matlala's application. That's the decision. Ms. Missy?
Chairperson, given the fact that Mr. Matlala, being our client, has now confirmed that he hadn't settled his mind, because we labored under the impression that this is where we're standing and these are our instructions, given the fact that he's of the view that he feels confused now, he's no longer with us, will you please grant us an opportunity to then finalize and get the instructions so we don't have this situation again?
Ms. Missy, the withdrawal of counsel and legal representations is not, strictly speaking, a matter of instruction from client. It's ultimately a decision taken by the legal representatives. They choose on their own, for whatever reasons, that we have now reached a point where we can no longer represent our client. Therefore, we are withdrawing as legal representatives. I don't know whether you are now suggesting that it was not a properly considered decision. I'm not pushing you to withdraw if you've suddenly become ambivalent about it.
Chair, remember we were operating under hypothetical instances. Now that we know definitively what your position is, I do believe that ought to be given an opportunity to finalize if really we're sticking to that position of walking away or not. As you've noted, that perhaps we might feel a bit of ambivalent and would feel we want to continue. This is what we're simply requesting, Chair.
Ms. Missy, what's happening now is deeply problematic. I asked you directly, is it your instructions from Mr. Matlala? You said yes. That's deeply problematic. Whatever stand down you get to go and consult with him, I would like you to end on that note from me. It's deeply problematic what just happened now, and I hope you find a way to address it. Because what it suggests and represents is what you said in response to my direct questions, is that is not the true position given what Mr. Matlala is saying now. If you come back to say it was a misunderstanding in whatever form, that I'm prepared to grant you that, but it is deeply problematic that you have put family, those are your instructions from your client, and now you say, well, maybe we need to go and discuss. I want you to understand my concern about it?
If I may, Commissioner, I do understand your concern about it, and that's the reason why I specifically have asked if the chairperson, the commissioners, could let us stand down, because I was laboring under the fact that those are our instructions. Now that he has intimated that he does not feel that he's on the same page with us and he does not understand, that implies that there's been a misunderstanding, and that's the reason why I would like for us to address this, so that when we come back before the commission, then we don't have this issue happening again. And to add over that, if you recall, this is a hypothetical situation that we're talking about. Now that you've made your ruling, that implies that we need to come back to the chairperson with a final decision of what are we going to do. Chairperson, I don't know if...
And as I said in my ruling, at this point, this is only about hearing Mr. Matlala's application. We have not reached the stage of the continuation of his testimony. That's where we are, just for clarity.
Thank you, Chair and Commissioners.
And Mr. Matlala, you are fortunate to have had lunch already. We are yet to have ours. No, I'm mentioning that because you said when you were having lunch earlier during the break that we had. Because it's 3 minutes before the lunch adjournment, maybe let's just take the lunch adjournment and resume it at 2 p.m. And let's hear from you, Ms. Missy, at that point.
Thank you, Chair.
And I hope everything will have been clarified, and that one way or the other will then hear Mr. Matlala's application, whether you continue to represent him or whether he is moving it in person. Let's adjourn and resume at 2 p.m.
Jotham Msibi, to whom I rendered security services. I never had any business dealings with them. I never sat around talking to them. I do not know any about their personal life or the business they are involved in.
Now, before you deal with the next person, at 89, you say you knew Mr. Msibi purely as a person to whom you rendered security services. I never had business with him. What do you mean by that last line, that you never had any business with him or businesses?
I will say I never had I attempted, yes, to do business with him, but it never materialized. So I never had any business without rendering security services with him.
And then while you are on that, what businesses did you attempt to have with him that did not materialize?
To purchase a private jet.
Yes. Any other?
No, it's only that.
Only that one.
Yes.
Were you then ever involved in any of his business dealings?
No.
Okay. Thank you. You then, from paragraph 91, at paragraph 91, deal with your relationship with the next person. If you could identify them and then read your paragraph 91 into the record.
Mike van Wyk, He was my business partner and is a witness in the Medicare matter. I am therefore exercising my constitutional right as an accused not to respond to or answer any questions pertaining to him or our relationship.
Now, he was your partner in the Medicare matter, and you say you are exercising your constitutional rights. I just want to understand, is this an exercise of constitutional rights in respect of any and all affairs of Medicare? Or is it only in respect of the SAPS contract for which you are currently facing charges?
Yes, only the SAPS contract.
Only the SAPS contract. Thank you. You proceed then to deal with the next person, and at paragraph, you identify them and deal with their relationship at paragraph 92, or your relationship with them.
Baron Mohoti, I have answered this aspect when I gave evidence.
So in effect, you're saying you've got nothing further to add to what you've already stated?
Yes.
Okay. Then lastly, I think at paragraphs 93 and 94, it's the last person.
Hangwani, Maumela, and Suliman Carrim. My legal team is in the process of collating evidence in respect of the said persons, which will enable me to move fully with awareness of an explanation of my rights, answer questions about them. I thus reserve my right to supplement this affidavit. I reserve my right to provide the Commission with any further and supplementary sworn statements necessary in these proceedings.
Can I just clarify paragraph 93? You say your legal team, quote, is in the process of collating evidence in respect of these persons being Mr. Hangwani Maumela and Mr. Suliman Carrim, which will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them, end of quote. Can you say that in simpler English? What do you mean? I understand that they're in the process of collating evidence in respect of these persons, but I'm not sure I understand the remainder of that sentence. Are you able to assist? What do you mean that the evidence that they are collating will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them?
I think this is a typing error.
Okay. So I'm not that bad. Let's try and correct it. What did you wish to express?
Documents that will support that I do not wish to answer these questions because of self-incrimination. This morning I have managed to get a document that I already supplied to my legal counsel.
I'm not sure I understand. It's a very cryptic answer you've just given, so I'm not sure I understand.
What I'm trying to explain to you is,
Yes.
like the first sentence saying that I'm in the process of collating evidence.
Yes.
So maybe I was supposed to say documents that will prove that I'm a suspect and I'm being under investigation together with Mr. Maumela and also with Suliman Carrim.
Okay. So, okay, I think I understand. So then you say your legal team is in the process actually of collecting documents that will demonstrate and prove that you are a suspect. I take it in some alleged criminal wrongdoing together with, not together, with Mr. Maumela and or Mr. Carrim. Is my understanding correct?
With Mr. Maumela, Chairperson, sorry, Commissioner, if you can remember, last week I already touched on the Suliman matter, and then you asked that I should bring an unsigned, what is it? An unsigned
Loan agreement?
loan agreement.
Yes.
So this is what I had that loan agreement, but I couldn't just find it. So what I had is only the document in relation with Mr. Maumela.
Okay, now, so you say that those documents will prove you a suspect. A suspect in what? Or which cases?
Suspect in, I think it is money laundering, I think.
And that is in relation to both the persons
With
identified there,
only with Maumela.
or with Mr. Maumela? And when can we expect these documents to be submitted? Because you say that your legal team is in the process of collating them.
They are already in possession of those documents.
Okay. I take it that they're in possession of the documents with a view to share with the commission.
They will advise on that because they are under investigation. I don't know.
Or you just gave the documents to your
Chairperson, if I may be allowed to address the commission in relation to that.
Yes.
We couldn't just take it off word that he says that he is a suspect, and we needed to confirm before he would be able to make such an allegation of vermin before the commission. And so he had to look for the document, which unfortunately, as I stated, he was unable to give it to us, rather the team yesterday. This morning he did give us the document, and it places us in a position where we can give, or rather he can make that statement on affidavit that he is a suspect and would be claiming his rights to privilege in terms of section 3(4). Sorry.
Now,
Would
is
need
it-
to supplement, if I may, would need to supplement his affidavit so that he's able to make those averments and give you the correct facts.
so is it the intention of Mr. Matlala and or his legal representatives to share the actual document that demonstrates he's a suspect?
Ms. Missy?
Chairperson, the issue that we're having is that we haven't properly looked at the document to determine whether, to what extent he can claim his right to a privilege. So provisionally, I would say yes, provided that we get a timeline in which we are informed that the supplementary affidavit needs to be in at a particular time. And then it allows us to look into the document and determine there isn't everything that's privileged that disallows us to hand it over to the commission.
Is there any problem sharing it with the evidence leaders right away?
Chairperson, I have not looked at it in detail. It's a document that immediately after we had engaged, we came down, he handed it over to me. I quickly glanced over it, so I can't answer that question definitively.
Is it a privileged document? Because if it is not, I would not understand why it cannot be shared immediately.
Chairperson, I suppose if you have to ask if it is a privileged document, I